take your seats and we will begin the legal report.
Thank you. Ooh, these kids. Okay.
All right, so counselors, I see on the agenda that we want to talk about some other items before we get to the legal report. So let's go ahead and start with ALJ cases.
Yes, so currently, we have a set of we have cases that come before you. If they go to formal hearing, and additional cases that will just go between an ALJ alone. Currently, our ALJ alone cases are going to be those that are E&O and failure to respond. And unlicensed activity. So today we're asking to expand that to an additional category of cases in attempts to alleviate some of the additional caseload that we've had in the litigation space. So the cases that we're going to request that would be moved to an ALJ alone case would be those that are related to advertising. As the advertising rules are pretty specific and clear cut in the particular rules, we believe that an ALJ would be individual that would be able to make those determinations. However, it's up to you and your purview. This doesn't mean those cases are absolved or go away. That just means that you would not have a hearing before you where we're making a determination if, texts are same size as bigger, or talking about ampersands as we've done in the past. So
It's not a logo, it's a work of art.
Oh, yes, works of art too. We looked at that as well. So this is just another thing to move to the ALJ.
Sorry, everybody, that was an inside joke, I apologize.
Or if you watch all of our meetings, you would know, but I hope no one does.
So, commissioners, I think she's asking us if we want to have a formal hearing about advertising violations. Does anybody want to have a formal hearing about advertising violations?
No.
So I'm guessing you need a motion for us to
Yes, that would be
delegate?
correct.
So I believe the motion will correctly say that we move to delegate the advertising violation courses to administrative law judge only proceeding?
Yes, that's correct.
Is that motion?
Second.
So you're going to make the
Oh, I
motion?
made the motion.
All right. Is there a second?
I made the motion.
Is there a second?
Second.
Ms. Smith makes the motion, seconded by Commissioner Moffitt. Any further discussion on this motion? All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Firm closures.
Okay, so this is related to specific rules. Hold on 1 second. I want to make sure I have the correct citation here. So Rule 1260-02-.38, it talks about the death or extended absence of principal brokers. And so in this particular instance, if the commission is notified within 10 days of the death, resignation, termination, or incapacity of a principal broker, then individuals are required to notify the commission of how the individuals are to continue operations without the principal broker. So they're currently, at this point, it states that the commission may, in its discretion, based on the merits and circumstances of each case, permit a real estate firm to continue operating without a principal broker for a period of not to exceed 30 days from the date. And then it states from within the aforementioned 30 days, the executive director shall have the authority to grant an additional 30-day extension for the closure of the firm, or extenuating circumstances of the firm. So what we're trying to do is we've been finding situations where we've had a lot of firms that don't necessarily have principal brokers, or they have principal brokers that are not in an active status. So we have principal brokers that are expired, principal brokers that are suspended, most likely due to E&O and those types of circumstances. And so we're trying to figure out what to do with those firms in that situation. So we've got the 10 days notification, and they have up to 30 days. And so we want to make sure that the commission is okay with the executive director being delegated the authority to give the additional extension for the firm plans related to beyond that 30 days. And then wanting to know if we have like the discretion if we send out this notification informations to close those firms. So what a closure of a firm would look like would be is that we would close the firm in court and notify the affiliate brokers that they would need to re-affiliate with another firm, and the rule states within 10 days. So that's what we're wanting to get, like some clarity of what to do in those kind of circumstances related to firm closures. There? Did I? Yes. Yes.
So when you say Ms. Baker would have the discretion, would it be the 30 days and then an additional 30 days, or just the 30 days?
It's, so the commission, it says in its discretion, can allow up to 30 days. So beyond, she can grant an extension afterwards, the rule states, but we want that 30-day period to be able to go to the executive director as well. So we're not bringing to you persons that are like, hey, we want 30 days, you know, to do the firm. So if they were to request that, then Ms. Baker would be able to grant that instead of it coming to you.
Okay.
All right, so we wouldn't be a bottleneck for it, essentially? Okay. But it's not, I probably didn't say my question. So it's just a 30-day period, but it's not going to be a total of 60 days?
So there is the ability to go an additional 60 days, and the rule states
Okay.
that the executive director does have the discretion to give the additional 30 days, but it says within the 30 days, the commission may in its discretion
I see.
permit a real estate firm to operate up to those 30 days.
Okay.
So there's kind of like a gap there in the rules, so we want to make sure if someone were to give us that 10 days that they have up until the 30, and then beyond that, the executive director does have the
So-
discretion to move forward.
Okay, so she would have the discretion to grant the 30 days?
Correct.
And then within that 30 days, she could grant an additional 30 days?
Yes.
For a total of 60?
Yes.
Okay, plus the 10 initially,
Right.
so 70 days total.
Question.
Yes.
Commissioner Gwynn?
When a principal broker dies, how do you get notified typically?
Typically, someone emails us the obituary.
And then what happens? Do you,
Typically, we're emailed an obituary. Hopefully, they'll also submit a Trek 1 for a
Who?
new broker, someone within the firm.
okay. What if there's nobody in the firm? I mean,
Then we issue a 10-day letter to all of the licensees in that firm requesting that someone become a principal broker.
okay. But do you delete like the person that passed away out of the system or?
They're marked as deceased.
Okay. And so if
Government always keeps the records, Steve. Government always keeps the records. I said
Yes.
government always keeps the records.
So
And
the,
it also prevents someone from trying to use that license.
if a
Yeah.
principal broker was a single person in their firm, he or she is a principal broker of a firm with no one else.
We would close that firm.
Okay. But you wouldn't notify, unless you're notified, you wouldn't know it unless,
Well, the firm license would expire.
Right.
when the expiration of the firm and you'd
Or
send
a
out,
family member notified us of their passing.
that would be a good thing, yes.
Yeah, we've seen we've seen both happen, someone within the firm or a family member.
Okay, thank you.
So in the 30-day period, is that when the affiliates are notified that they need to
They
hang their license?
received the 10-day letter,
So
the
they got the
first 10-day
10-day
letter.
letter? Okay, but,
And the 10-day letter states they have to move their license within 10 days, or they have 30 days?
A principal broker needs to be affiliated with this firm within 10 days.
And if it's not,
then,
That's what we're requesting.
so I guess the hypothetical we're trying to get to is, they got the 10-day letter. That 10-day letter.
We're doing two different things. One, we're trying to grant me the authority to grant the first 30-day extension. And then the second thing that we're requesting is the ability to close a firm if after X amount of days, a principal broker is in place.
It's not in place.
Correct. Trek is being very proactive. We are in a season of being proactive, and so now we've searched the system for firms without active PBs. And so a gentleman that was here today was here because we searched our system for firms that did not have active PBs, but they had an active firm license. And so we issued 10-day letters to, I can't remember the number of firms, I should, to several of those firms. Some of them granted an extension. I did grant a short-term extension for the gentleman that appeared today. That way, we could see what you all would have decided with the waiver request that he presented today.
Right, and I think that we're just trying to understand the mechanics. So after the 10 days, 10 days lapse, there's no PB.
Then it should come before you all to grant a 30-day extension. But with us moving to every other month, it would be best if I had that ability to grant the initial 30-day extension.
Okay, but, so the affiliates that are still at that firm, do they need to move their license at that point, or can they stay pending a new PB?
Pending what happens and if a new affiliate broker, we've had instances where an affiliate broker steps up, but they need time to study for the principal broker exam or for the broker exam. So there have been situations where they want a week or two to prepare for taking that exam. We've had situations where they failed the first time and need additional time to study and take the exam once again.
Okay.
So,
So, but the affiliates would be able to stay during that
Yes.
30-day extension?
yes,
And then possibly for another 30 days after that?
possibly, yes.
Okay.
So they have to request a 30-day extension?
They have to request.
Or it's 10 days?
Yeah, within the first 10 days, they're supposed to request an extension, yes.
Okay.
And in that time period, they're required to give us a plan of what they're going to be doing with the firm. So if the plan is to have someone sit and test for the broker exam, that's what they're doing. Or if the plan is to find another principal broker to fill in or to close the firm. So we need some kind of plan letting us know what the future is going to be for that firm.
Okay.
So basically, the request now is to allow a decision to be made by Ms. Baker during this period of time when we're not meeting, correct?
Correct.
So that's really our only motion, correct?
Yeah, yes, and so we just also want, for that 30 days for it to go to Ms. Baker instead of
Coming to us.
to you all.
Okay.
And this is the first 30 day, this is the 30 days after
So
the
it'll
10th.
basically, any of decisions related to this will go to Ms. Baker.
So if there was a second 30 days,
Ms.
you
Baker already has the discretion to handle that.
on the
So-
second 30?
Yes. So there's a gap in the rule saying the commission has the discretion from like day 11 to day 30 to grant, and then day 31, Ms. Baker has the discretion, so we're asking for basically the discretion, all of it, to go to Ms. Baker.
Okay.
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 So moved.
So I have a motion. Is there a second?
Second.
Just so I can state the motion for the record, the motion is to delegate authority to the executive director, Ms. Baker, to grant the first 30-day extension for firms that are without a principal broker due to incapacity or death. Does that sound right?
Yeah.
Okay. And then we said something about closing the firms. Does she need authority to do that as well, or do you want a separate motion?
We'll do a separate one for that.
Okay. That motion was made by Commissioner Gahn, seconded by Commissioner Smith.
So it would still apply if the broker just resigned?
So if the broker retires, then yes, it would be, this role is really supposed to be for like the if someone's incapacitated or has an extended leave of absence, due to medical reasons. So if a principal broker just retires and abandons their firm, I guess that could happen. And it would probably fall into that category if that's the way that you guys read the rule that way. It would apply, but hopefully that's not the circumstance.
Well,
It's
it could be
for-
like a multi-office where a broker resigns and they got somebody they want to take that place, but it's going to take them a while to test and go as well.
Right, so they would just need to notify us of that, but hopefully in that situation, they would not retire until that that plan is in place. So this is where we have an immediate need, not something like, hey, I'm going to retire in December, so if
Yeah.
they would have that time, to make their own arrangements. This is for like those immediate things that we don't really foresee.
Yeah.
So if someone has to take like immediate medical leave, or if someone passes away, unfortunately, those circumstances, not really for the ones where the principal broker wakes up on a Thursday and decides to retire
Quit.
or quit.
Alright.
I'm
Any-
feeling like this is, okay, a specific situation. But yeah, so that's what this rule is supposed to be for. But if that situation were to happen, we would, of course, still send that 10-day letter letting them know, hey, you don't have a principal broker. Your firm we needed something to do to figure out how to keep going.
Okay. Commissioners, any further question on the motion? Let's go ahead and vote. All those in favor of the motion, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. On to the legal report.
Well, we do want to talk about firm closures
Oh, okay,
really
firm
quickly.
closures, go ahead.
So it's kind of in the same thing. So in those circumstances where we don't have any response past the 10 days, or if give the extension and on day 63 we still don't have anything, we'd like the permission to be able to close those firms at that time. So
And they'll get notices and all that kind of stuff
yes,
along the
the
way.
notices will go out to the affiliates, letting them know the closure of the firm and that they have the 10 days to reaffiliate with another firm or to place their license into retirement.
All right, so the motion would be to allow, will this go to again to Ms. Baker?
Oh,
The
in those
authority?
yes, so,
Okay. So motion is to delegate to the executive director, Ms. Baker, the authority to close firms who do not appoint a replacement principal broker within the allotted time of 30 or 60 days.
or just like failure to respond to the
Failure
notice.
to
Yeah,
respond.
Yeah.
Somebody want to make that motion?
I'll make that motion.
Motion by Ms. Smith. Is there a second? Seconded by Commissioner Moffett. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Ms. Matlock, anything else?
No?
Okay. Ms. Cooper, you gave us a supplemental at the beginning of the meeting.
I did.
I'm just going to go ahead and renumber those so we
Okay.
can consider them on block. And let me get to it. The cases on the supplemental are going to be cases 122 and cases 123. Sorry, let me get organized here. All right, so as part of our preparation for this monthly meeting, the department staff prepares a legal report for us, the council prepares a legal report for us, where they summarize and produce a narrative for us to read, so we understand the charges, the allegations, and the response, and they also provide us with a recommendation. Commissioners have the discretion to pull cases that they would have questions about and would like to discuss further, and we refer to those by their case numbers as they are given to us in the legal report. So I will read those numbers that commissioners have chosen to discuss further into the record, and those cases are case number 2, case number 4, case number 5, case 12, 21, 43, 45, 55, 56, 60 and 61, 89, and 90. And council has asked us to discuss case numbers 14 and 15, 53, and 89. Besides those cases that have been read into the record, do commissioners wish to pull any other cases?
Yes.
Commissioner Gwynn.
Number 8.
Commissioner Gwynn asks to pull case number 8. Case number 8 is added. Any other cases?
What about the two we just received? We hadn't had a chance to look at those.
Commissioner Smith, did you want to talk about case 123?
No,
No? You didn't have questions about that?
I just thought it was a similar one, but no. Let's see. I'm good with the decision. It's just a $500 penalty. I'm good with that.
Okay. Okay, so minus the cases that have been read into the record to discuss further, is there a motion to accept council's recommendation on cases 1 through 123?
Make a motion to accept council's recommendation with the exception of those numbers called out prior.
Commissioner Smith makes a motion to accept council's recommendation, seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 2, Commissioner Smith.
Yes, I had a question on this one because it was talking about an updated property condition report. Kim, I think this must be you.
Yes, ma'am. Most of them are mine, yes, ma'am.
We're gonna be good friends, aren't we?
Yeah.
So I guess I agree with the letter of warning, but I think in practicality, the complaint is they felt like the updated property condition report wasn't being done in a timely fashion after a home inspection. So I was just curious about the time frame between the inspection and when they thought the update. I know sometimes we get those reports and we tell the seller, everything falls through. We tell the seller starts repairs, but it's difficult to do a home inspection update when there are ongoing repairs. So I was just curious about the time frame there.
It was a little less than 2 weeks.
Less than 2 weeks from the time that it should have been an update and it wasn't an update?
From when they received the report and to when the complainant noticed that it had been relisted. And
Relisted.
And that the property report had not been updated.
It was a 2-week time frame.
Yes, ma'am.
Okay.
So if they were doing the repairs after they got the report, why would it need to be updated?
Well, my question is.
Because I might go on a pre-listing appointment and see there's a lot of repairs some repairs that need to be made.
Yep.
And they make those repairs as we're listing the house, but we don't include those on a property disclosure because the repairs have been made. Would that not be the same here?
I would defer to the professional practice to you all. My concern only was that the complainant seemed to have a legitimate concern that there wasn't an updated report, but as I pointed out, the respondent said, I was giving the report to those that were interested, I just hadn't updated it on the, I guess it was the
MLS.
Yes, ma'am.
Right. I guess from a practical standpoint would be, assuming a home inspection was done and there's a list of repairs that are requested, and then we would want a new update. But sometimes it takes more than 2 weeks to get those repairs done. So I'm concerned that there was a limited amount of time there. So I'm not sure the letter of warning is justified in this situation.
And again, I would defer to you all. I didn't think it rose to the level of needing to be
Yeah,
a
but-
consent order or a civil penalty.
Right.
Which is why I kind of went in the middle with the letter of warning.
Right. I think it depends on the
So-
time frame here,
So
too.
you're saying that because it was only 2 weeks, that there wasn't enough time for repairs to be done in that time frame, possibly?
Possibly, but we
Possibly.
don't know what the repairs
We don't
were.
know what the repairs were, so,
If they said, put on your roof, I don't know that you can get a roof put on in 2 weeks. Although they're working on my roof right now as we speak.
and they said it would take 4 days.
And they said, take that.
Apparently you have a lot of peaks and valleys on your
Or they're being paid by the hour, I'm not sure.
Danny?
I'd like
versions of the
I'd like to
money
make a
pit in my
motion
head
that we
now.
dismiss this.
I'm going
There-
to second that.
Motion by Commissioner Gahn to dismiss case number 2, seconded by Commissioner Smith. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 4. That's me. Yeah, I don't have a question about this. I don't have a quibble with the letter of warning. I was just wanted to suggest that in that letter of warning, you remind the respondent that they have the ability to add an alias or an AKA, so that when he signs his name and he doesn't exactly match what's on record with the commission, we don't have to hear from him again.
Yes, sir.
Thank you. Other than that, I'll accept a motion to accept council's recommendation. Is there a motion?
So moved.
Motion by Commissioner Smith to accept council's recommendation as amended. Seconded by Commissioner Moffett. Any further discussion on the motion? All those in favor, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 5, Commissioner Smith.
That's me. I just wanted clarification, because in this, this is the response. Let me find my sentence. We were able within 10 days to make the correction before being fined. I was not given that opportunity and should not be subject to the fine, since I was made aware of the violation in the same email in which I was notified of the fine. So I'm just clarifying for those who may be listening. So when you are sent the letter and says you have a problem, you're also sent a letter saying, and you owe this, correct? In the same correspondence?
I will defer to Director Baker for that, but it is my understanding that in this case, what the complainant was talking about was the agreed citation. They received the agreed citation, and that's the email that they're saying they
Right.
were notified they were in violation. I was also surprised to hear that there's a 10-day grace period somewhere in the ether out there, but that's what they're referring to.
Yeah, I mean, if Anna's turning up her palms and shrugging her shoulders, I don't think there is a 10-day grace period.
Yeah.
But,
I would
because that
agree.
was news to me too. I was like, huh?
Right.
So,
Glad it was news to everyone.
so, Joan, I mean, council's recommendation was to dismiss.
Dismiss.
Do you have any other recommendation?
I'll accept council's recommendation.
I have a motion by Commissioner Smith to accept council's recommendation to dismiss case number 5, seconded by Commissioner Moffett. Any further discussion on the motion? Hearing none, all those in favor of the motion, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. Case number 8, Commissioner Gwen.
Yes, this is a landlord-tenant situation, and I'm curious why you thought the agent did anything wrong as far as, you suggest a letter of warning for reasonable skill and care, and it looks to me like the agent pretty much did what the complainant is the landlord and the one that signed the lease. So whatever problems that he or she may have had with the lease, they did to themselves. So I think we should dismiss it myself. I'm just curious why you thought a letter of warning was in order.
The reason that I did is because the complainant stated that they hired the respondent in the sense of a property manager and to help them find a tenant for this property. They helped prepare the lease, which I've provided to you all.
Right.
The pertinent section. In my opinion, I'm an attorney, so I'm a little more stickler maybe than this respondent was, but in my opinion, the waiver section there was sloppily done. It should be completely filled in. That was the complainant's complaint as well, that they relied on this professional to take care of that for them and point out any pitfalls. And so that's why I suggested the letter of warning.
So the form was the RF 421 roller form. So the X for the driveway was filled in, but other things were not filled in, like carpet or flooring?
Correct. exterior
So-
walkways, the fence, the interior walls, and from the complaint, it was some extensive damage to the areas that are not
Checked.
taken care of on that waiver.
But the landlord made some other changes to the form lease,
They did make some,
like pets and
ask for
whatever.
some suggestions. yes, sir.
So it would seem to me that he or she knew what they were doing to tweak a form lease, and maybe they wanted it that way. That's what I would think, but maybe not.
Well, and I think the complainant is also saying, you know, it's kind of their fault for not reviewing closely the agreement before they signed it, but that maybe they would have noticed these errors or these omissions.
Did we get a copy of the special steps,
Did we get a copy of what? I'm sorry.
special stipulations?
Yes, sir.
And it wasn't in there as well?
What was damaged and what was discussed? No, sir.
So does the line item down there, any item not mentioned herein, et cetera, does that have any controlling interest in there? Like, if it's not checked, that it defaults to one party or the other?
I don't believe so, because it's the four corners of the document, so it doesn't help any that this case was taken to a general sessions court for damages, and it was dismissed because the judge informed the complainant that because these sections were not marked, they could not obtain damages against the tenant.
Oh, okay, so he lost in court, and then he went after the agent?
Yes.
Is that what that's what that
Saying
is?
that
Okay.
you should have done this, or I could have gotten the damages back.
So he's alleging that because of the
Even though
mistake by the
Yeah.
agent,
Correct.
that it
even though he
cost him-
signed the lease,
He did sign it.
hmm?
He did sign the
He
document.
signed the lease.
He did, which is why, or they did, which is why I'm asking for a letter of warning and not necessarily a civil penalty. I believe that, again, this was sloppily done. They need to do better, but there were mistakes on both sides here. But they're the professional, they're the licensee, and I think that they need a letter of warning.
All right, I agree with council's recommendation.
Commissioner Gwynn makes a motion to accept council's recommendation on case number 8, seconded by Commissioner Moffett. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Commissioner Smith, case number 12.
Yes, this was a complaint. So my question is, so was the complaint filed against the wrong agent? Is that what's going on?
That is what it seemed like, but because it was anonymous, I couldn't follow up with them. So, but
Right.
the respondent passed it on to their principal broker, who responded and said, this is not my agent, this is not who did this. They, of course, could look up the listings and figured out, obviously, who it was and let them know, and that principal broker took care of it. So, in any event, this needs to be dismissed. If you would like to suggest that a complaint be opened up against the correct principal broker, obviously, that's within your purview. But as to this respondent, I recommend dismissal.
So was the principal broker at a different firm,
Yes,
complete different firm?
yes, ma'am. I'm not sure where the mix-up came from the complainant, but yes,
Right.
ma'am.
So is this the, what statute or rule are we operating under here for this one, if any?
False information.
The
False information, false or
false
misleading?
information or to keep it updated and timely.
Updated and timely? Okay.
I'm blanking on the specific rule
Yeah.
subdivision, but yes, sir.
I'm gonna make a motion to dismiss this complaint, but open up a complaint against the broker that was responsible. And I'm assuming you have that information.
So-
Yes, ma'am.
Second.
All right, Commissioner Smith makes a motion to dismiss this case, case number 12, and administratively open a complaint against the principal broker of the offender, can you say offended? Of the other firm that is responsible. Seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed?
No.
I have a vote of 5 yes, 1 no. Commissioner Gahn voting no. Case number 14, that is a discuss. Counsel, what do you want us to know about this?
Case number 14 and 15 are actually related. They are the same, it is a firm and it is the principal broker, and owner of that firm. My concern is based on the facts as alleged in complaint number 14, and then the lack of response in the first case and the lack of response by the broker in their own case, that we've got a broker here that is kind of, to get back to the discussion we had with Ms. Matlock, that has potentially abandoned their firm.
Okay.
And so there might be something more than just a civil penalty that is warranted here.
Took the money and ran, huh? So we got a principal broker ostensibly writing bad checks from a escrow account,
Correct,
and then apparently took off.
correct.
So does that be a referral to the Attorney General will be on the table, or
It's actually already with the local law enforcement.
local law
Oh.
enforcement?
Well, there you go.
And I'm guessing since the respondent is not responding at all, what little hope do we have of tracking them down and collecting any kind of civil penalty or whatnot from them anyway?
On the civil matter, yes, the law enforcement may have a better chance at that, yes, sir.
But if we put a civil penalty on him, if he ever tries to get his license, he'd have to pay that civil penalty, correct?
Correct.
So,
Yeah.
so if we were to suspend a license, a firm license or a broker license, obviously that, we're going to send that out as a consent order,
Yes, sir.
and then we would serve process on that. Theoretically, they don't respond because they're not responding to anybody.
Right.
What happens to that?
We move to a hearing. I go ahead and
You
file
move
a
to a
notice of
hearing and try them
charges.
in, try them absentia?
Yes, sir.
And that would be ALJ alone, or would that come to us?
This would be before you all because it involves the escrow funds.
Okay.
So you suggesting?
Exploring options, yes. I'm also, closing flag is an option. Although that keeps their license active
Yes, sir.
until it expires.
I like suspended.
You gonna make that a motion? You want to suspend the firm or the PB? Or both?
Or both.
Okay. What is your motion, Commissioner?
Okay, let's back up just a second and think about this.
Right.
This person is the principal broker of this firm, but it doesn't necessarily mean they're the owner of the firm.
It does not.
15 is against.
So my recommendation, my motion would be to suspend the license of the individual.
Commissioner Smith makes a motion to suspend the license of the principal broker, seconded by Commissioner Moffett. Any further discussion on the
That's
motion?
basically number 15 then, right?
Yeah, they're both linked, yes, sir.
They're together, right?
So we're doing nothing on 14?
We're
They're
doing both
together.
14 and 15.
Oh, we're
together.
suspending the firm and the broker.
No, I only did the
Well-
broker because the firm may not be.
Correct, but what are we doing on 14
Well,
then?
we might not, we might have something to do if you want to
14,
make a motion.
14's a firm and 14,
Right,
15's a broker.
Okay,
So we're going to suspend the license of the principal broker for case number 15.
For a term of what
For how long?
period?
I know,
You think?
I'm thinking.
How about till February the 4th, 26, when the license expires anyway?
Okay.
I'm okay with that.
Okay, so the, restate the motion is to suspend the license of the principal broker in case number 15 until February the 4th of 2026. Is that good with you, Commissioner Moffett?
Yes.
All right, we have a motion, it's been properly seconded. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion at case number 15, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. What would we like to do with case number 14?
Can we request an audit
That's in my notes too.
Yes.
Yes.
Well done.
So I'd like to make a motion that we request an audit of the firm's escrow account.
Commissioner Gahn makes a motion to audit the escrow account of the firm in case number 14. Is there a second?
Second.
Seconded by Commissioner Moffett. Any further discussion in the motion? Do you need a time limit, or is that just going to go and do what it does?
I would
The
think that
audit-
they've moved pretty quickly on that, so.
The audit would, sorry, I had to look at today's date. We would,
16th.
thank you. We would send out letters for the audit telling them that the firm was going to be audited on the first week of November. It's hard to believe that we're near the end of the year, so.
And then, given their track record, we're going to assume they're not going to respond?
I'm hopeful,
You're hopeful?
but, you know.
Okay. So if they don't respond, so that would be another case that
If
comes before us?
if they did not respond by the end of November, a complaint would be submitted for lack of response, and then it would probably be before you all, probably in February.
Okay.
It would be too close of a turnaround to get that on the December agenda.
So do you want to declare that this firm doesn't have a PB? Since they're not
It might
responding
be too
and
early to do that.
I think it's
too early?
Yeah, we have to see if they signed the consent order.
Okay.
Because if they don't sign the consent order, then
Do we know if the firm has any affiliates?
I
They
can-
do.
They do? Thank you, Ms. Cooper. Okay.
Does that put consumers, the public's money at risk by any deposits being made to that escrow account?
That's what the audit would determine.
So, just for additional information, Commissioner Rampey, whenever a suspension is issued, the respondent has to agree to the suspension. So if they did not, then the matter would go to hearing. The only time where the commission is able to suspend a license immediately would be in the case of a summary suspension. That's not what's before us right here. We've only had, I believe, one since I've been here. But that's when it's like a little mini kind of hearing thing where we determine if the health, safety, and welfare of the citizens are at risk. It's pretty high standard. So the last time we did that, someone sold a house twice. And there are pending criminal charges related to that. So that's the only time where we could automatically suspend a license.
Okay.
Okay. So we have a motion for the audit. It's been properly seconded. Is there any further discussion?
Quick question,
Commissioner Gwynn?
Ms. Cooper. The person that is looking for their $1,000, you said they turned it over to the police?
Yes, sir.
So they're not out-of-pocket money chasing 1,000 so far, or are they?
They are. They have not been
Ugh.
able to get their money back.
But it hadn't gone to court yet.
No, sir. It's
Okay.
an active
All right.
criminal
Okay.
investigation. Yes, sir.
Any further discussion or questions? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 21, that's me. Okay. The discipline history of this case is what attracted my attention.
Yes, sir.
We've got 8 violations over 6 years. A lot of E&O insurance and advertising violations. And then this is yet another advertising violation. I would go ahead and go for the full 1,000 here
Yes, sir.
rather than 750. And I don't feel comfortable just doing that because I feel like they're kind of shrugging their shoulders at us with the number of violations that they have. So I would entertain a more severe penalty if commissioners are so inclined.
So we can also open up a case against the principal broker for failure to supervise.
Absolutely, that's within your purview, yes, sir.
Are you making a motion, Mike?
He hasn't yet, but he certainly could if he wanted to.
Yeah, I'll make a motion that we open a case against the principal broker for failure to supervise.
Okay.
I'll
Yep.
second that.
We have a motion to administratively complain against the principal broker in case number 21, seconded by Commissioner Smith. And the motion was made by Commissioner Gahn, seconded by Commissioner Smith. Any further discussion on this motion? Let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Does anybody want to do anything to the affiliate broker in this case?
I do.
Commissioner Smith?
I want to do a recommendation of $1,000 penalty for violation on the advertising instead of the $750.
Second. I have a motion by Commissioner Smith to increase the penalty in council's recommendation from $750 to $1,000, seconded by Commissioner Moffett. Any further discussion on the motion? Is there a class on advertising rules, or
No, not really.
can we do the tracer course?
Do what?
The core course does go over advertising rules that they're
that-
supposed to take every
Wanna
2
add that?
years.
There are also components of Trace that go over it as well.
Absolutely.
Commissioner Smith, what do you think? It's your motion.
Well, let's add to this motion. To complete the trace course within 6 months.
Okay, so to restate the motion, Commissioner Smith makes a motion to increase the penalty from $750 to $1,000 and to require this affiliate broker to take the trace course, a 30-hour trace course,
Yeah.
and complete it within the 6 months, and to that course not count towards their continuing education.
Correct. And let me also say that when we see a violation like this and we have 6, 7 lines of complaints, it makes us a little bit more cautious.
Okay? Everybody good with the motion?
You good?
Any further discussion? Hearing none, let's vote. All those in favor of the motion in case number 21, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 43, I think that's me. It's both of us, Jim. How about that?
Imagine that.
Ladies first.
Let's see, let me go back and see. I think this was the case where property was listed by an agent who had an ownership in the property. Let's see, that's correct, yes. And it's our responsibility to notify our clients if we have an ownership in the property. But they're saying that they signed it, but they didn't upload the document. Let me skim read again.
They said they uploaded the document to the MLS, but not to the public-facing portion of the MLS, and so it was only, I guess, registered agents that could
That
pull
knew
that
that that
document
was
up,
it.
yes. So the general public would not
Did
have that
not,
information.
and that's what the complainant's upset over.
Yes, ma'am, until they made an until they made an offer, then it was disclosed to them.
I see. So your recommendation is a letter of warning?
Yes, ma'am.
And so I'm guessing complainant was representing a client that was interested in the property?
They didn't specify, but that's
specify?
the impression that I got, yes, sir.
Do we know if the complainant is a member of their local board or not?
The local board, I don't have that information.
You don't have that information?
We don't keep track of
Fair enough.
membership in associations.
I make a motion to accept council's recommendation.
I have a motion by Commissioner Smith to accept council's recommendation in case number 43. All those, seconded by Commissioner Moffett. Any further discussion of the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 45, Commissioner Smith.
Did we both pull that?
No, I didn't pull that one.
This I thought was really strange. They've been doing this for 24 years, but they have not been advertising it correctly for 24 years. Is that what I saw?
That's entirely possible.
Again,
The advertisements
We
that I was.
operate on complaints, Commissioner Smith. you know?
Correct.
I know, I can't believe 24 years, somebody hadn't got their hand slapped.
I was a little surprised myself when I got the response, but the complainant provided 26 current advertisements that were not right.
Which justifies the $7,500 penalty.
I felt so, yes, ma'am.
Are they working toward getting a license, or are they just still,
They say they're not doing anything wrong.
So are they
You think
a
75?
wholesaler? Are they claiming to be a wholesaler, or they're just, are these properties that they own, any exemptions at all?
Not that I could find.
Not that you could find.
It's not a resident manager, it's not, these advertisements are contact this person to purchase this property. And
So
it's-
the complaint says the type of license is a real estate firm. So ostensibly it has a principal broker in there somewhere.
Correct, the principal brokers who responded.
so what you're telling me is this person is still actively pursuing their business model that they've been doing for 24 years?
Because as far as they're concerned, they're not doing anything wrong.
So-
Yes, ma'am.
So, so,
I'm
so
trying to
he's
keep
saying,
asking
no,
this
wait a minute.
question.
So he's saying
The
that this.
answer doesn't change.
What?
Yes,
So wait a
ma'am.
minute. So he's saying that this employee is only selling or leasing properties owned by the respondent, the principal broker.
Correct.
That's what,
Wild
Now,
statement.
the respondent is the employee.
the respondent is the
It's
principal broker.
The respondent is the firm. The complainant
Firm.
made a complaint
Yes.
against the firm for having this unlicensed person.
And then she said the principal broker was the one who responded.
But do you know what kind of employee he is? Like, is he an accountant or a?
It seems to be.
They're
their
not a real
assistant.
estate licensee. They don't have a real estate license.
But I can sell my own property.
Yes,
You can.
but you can't have an employee do it for you without a license.
I was assuming it was the employee or the employee's property.
No,
No.
it's not the employee's
That's the
property.
respondent's property?
It's
The-
either it has to be the principal broker, but it's not the property of the person who is advertising or sale all of these properties.
We don't know who owns the property. We don't really know who owns
We
the
don't,
property.
I don't really know, but it's not the one that's on the ad.
Oh, this is excellent. This is great. This is good. I mean, there's got to be something else in the statute we could throw at this person.
You know, he doesn't really declare
What do you want
whose
to do?
property he's selling. He doesn't really say whose property he's selling. He doesn't say, he's just saying that,
Well, he says in the last sentence of his response,
yeah.
this employee has worked for their firm for 24 years, has sold and leased properties owned by the respondent, and therefore is not required to have a license.
Well, he wasn't selling
That is
his
not
own
what the
property.
statute says.
That's amazing. I don't know, Joan.
Sounds like it's a builder.
I think council's right. You think it's a builder? Okay. Well, they can get our consent order and decide what they want to do after that.
I agree. I make a motion we accept council's recommendation and let them come back and we'll go from there.
Got a motion by Commissioner Smith to accept council's recommendation in case number 45.
Five.
Seconded by Commissioner Moffett. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 53 is discuss. Ms. Cooper, what do you want us to know about this one?
Let me get to this one.
They're asking for breaks.
53?
53, I had a recommendation.
Yeah, they got a recommendation.
I think it's 54.
I'm sorry, I apologize. That's right, 53.
53, I think might have been me.
Oh, okay.
No, it was me. It was
Oh.
both of us, actually.
Okay, well then you take it.
I'll take it this time, okay. All right, so, let's see. So this is an advertising violation for a website,
Yes.
Yes,
not having their contact information and firm name conspicuously displayed. Respondent stated they retired their license. The advertising So do we know when the advertisements were removed? Was it after they received the complaint? They removed them?
after they received the complaint.
They received a complaint, then they retired their license. And then they took all the advertising down.
That's what the respondent said, yes.
Okay, so complaint, took down,
Retired.
retired.
No. Retired, receives the complaint,
And then took down.
and then responds, hey, I retired my license, I've already taken these down. Please have mercy on me and don't give me an advertising
Yeah,
violation.
I saw the mercy.
Yes, ma'am.
Excuse me, the grace.
The grace.
The grace, I'm sorry.
Maybe it was that 10-day rule that we were
Yeah.
unfamiliar with.
I mean, so you think a reduction? Or do you want to dismiss? Or do you just want to hit them with the 500? What do you want to do?
You know, they retired their license and they're going away. Is that correct?
No.
No, they could
No,
come
a
back.
retired license,
They can come back, but if we have
$25.
something on file, then like a letter of warning or something like that, we could have a letter of warning. So
So-
if they want to come back, that letter of warning is there, but it doesn't really cause any consequences.
just like the 2020 letter of warning is in their history.
Yeah, doesn't do anything. Okay.
I didn't say that, I didn't.
I know, you didn't have to, it's right here.
Okay.
It's right here, I saw it. So I'm going to make a recommendation that we reduce the civil penalty to $250. That way it has to be paid should they want to reinstate their license, correct?
Yes, ma'am.
Thank you.
And
If
That's
the-
in a form of
05 means they're not grandfathered out of CE, right?
Will you repeat your question?
They were first licensed in 2005, so they're not grandfathered out of CE.
I don't believe so.
Okay.
I was just, we got a motion.
So there's a motion for council's recommendation to be amended to reduce the fee to $250, seconded by Commissioner Moffett. Go ahead, Commissioner Smith.
Well, I had a question. I was just curious how long that had been going on. But they've already taken down the information, so you can't really tell how far back
Correct.
it was on there. Okay.
So if they say, I'm not going to pay it, what do we do? Go after them?
Have a hearing. I'll file a notice of hearing and charges.
But they're retired, so,
With the ALJ.
so
ALJ alone.
As long as I can serve process on them, we'll have a hearing.
No.
over 250?
Yes, sir.
Okay.
Not only that, but cost as well. So
Yeah, court
once a notice
costs.
of hearing and charges is filed, costs come
So-
into play.
For their benefit, they would be smart to pay the 250, not to have this hanging over their head, even if they're out of the business.
I think the commission is showing grace.
At
by-
250?
Yes.
I agree.
Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 55, Commissioner Smith.
Okay, on that one, it says respondent did not reply to the complaint.
Yes, ma'am.
So do they still get the $1,000 penalty for not,
They're- They're not licensed.
they're not licensed, so we can't really do anything.
Correct. The licensees are the ones that have the responsibility to
Okay.
reply within
Just
10
want to be
days.
sure I'm clear on that.
Yes, ma'am.
Do we know if this has been referred to the Attorney General's office or another body?
They said in their complaint that they had, how do I put this? Referred it to everyone that could possibly
Okay.
have jurisdiction over this.
Okay. I make a motion to accept council's recommendation.
Commissioner Smith makes a motion to accept council's recommendation to dismiss this case in case number 55, seconded by Commissioner Moffett. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 56 is
It must be you.
just
It's
me.
you.
It's just me. How about that?
Good for you.
So This is interesting. So this is also unlicensed.
Yes, sir.
But in this, your recommendation goes from dismissed to the civil penalty
For unlicensed activity.
for unlicensed activity. Tennessee land for sale. So were they licensed at one point, or is this just because of their activity, they're engaging in real estate and they don't have a license?
Correct.
Okay.
And this was not their property.
Well, they didn't respond.
They didn't respond.
So if they would like to supplement, or provide a response where they prove that they have ownership, but the way that the advertisement was presented, no.
Okay.
Well, when they get the civil penalty, they'll respond.
Well, or,
So,
so, I'm sorry, I'm just gonna say, council's recommendation was to issue a $1,000 civil penalty for unlicensed activity. Commissioner Gwynn?
so are we limited on civil penalties to licensees?
No, we issue civil, you
No,
all issue-
so the limit on the civil penalty, is it only apply to a licensee or to a citizen that's doing unlicensed activity that's never been under the Tennessee Real Estate Commission purview? So,
well, they're not under the purview in the
words-
sense they don't have a license, but
Correct.
that's because they're choosing to do that. So
Correct.
The unlicensed activity, to remain consistent from what you all have practiced for quite a while, is that it's $1,000 for unlicensed
Right.
activity. Yes, sir.
And
But
I
we
think-
couldn't-
I think we're also, our authority is to give civil penalties up to $1,000. I don't think we have the authority to exceed that unless there's a separate violation
I believe it's per incident.
per incident, yeah.
but I'm saying, does the authority only apply to licensees? In other words, we couldn't make this 10,000.
So we assess civil penalties to licensed and unlicensed persons. The range for civil penalty is 0 to 1,000, and that is supposed to be against per incident or per day. So that is the gamut of what you have.
Okay.
So if there were to be, like, for example, if there were 16 properties, you could assess a civil penalty of $16,000, $1,000 per property. However, here we only have $1,000 one property, so
I thought we had
we have two properties, so could be $2,000.
Okay, because we have two properties.
Technically, yes, ma'am.
Okay.
And we could also start a clock from July 14th when the case was opened.
You could, I would have to show,
I just said that to get Anna's reaction, I'm sorry.
well, you got mine too, so.
Got your attention, didn't it?
It did, yes, sir. Yes, ma'am.
Okay, so council's recommendation was for 1,000. It seems like we have the ability to go up to as much as 2,000. Is there a motion?
I'd make a motion to go to 2,000.
Commissioner Gwynn makes a motion to change the council's recommendation to a civil penalty of $2,000, one per piece of property, $1,000 per property, seconded by Commissioner Moffitt. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 60, Commissioner Smith. Hey, you chose them.
I was on a roll, wasn't I? Let's see.
Can we just do 56?
No, we're on 60.
We're on
Oh,
60.
Oh, I think my question was, is this out of our time frame?
That is my concern, that if I had to have a hearing on this, that there is a legal defense because we did have notice of it in 2017. I discussed that with co-counsel and with chief counsel, and they asked me to present it to you all to determine how you would like to proceed, but that is my recommendation.
So are these people still working together, still
Oh,
principals?
no, no. They,
Gone away?
for 8 years now. Yes, ma'am.
I'm going to I'm going to recommend that we dismiss this one based on time.
Got a motion by Commissioner Smith to accept council's recommendation to dismiss this case. in case number 60,
Yes.
seconded by Commissioner Moffitt. Any further discussion on case number 60 in the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Commissioner Smith, case 61.
We talked about this one a little bit a while ago, and that was where, and I'm going to read, respondent's affiliate murdered the affiliate's spouse, who was also an affiliate under the supervision, then took his own life.
Yes, ma'am.
And the respondent and their staff were under a great deal of strain, so they did not submit the broker release for the affiliate. Talk to me.
So, obviously, as they're deceased, they don't need E&O insurance anyway. But
Right.
a complaint was opened, it was referred to legal, so I'm presenting it and asking you all to, actually, if you want to dismiss, that might be the better recommendation. But this was a horrible situation, not to make light of it, it was a horrible situation, and I agree with the principal broker that it just needs to go away.
I mean, how do you do a letter of warning?
It would,
You
it-
don't have to.
we don't have to, but it would be to the principal broker. But I mean, I should have just said dismiss.
I'm going to make a recommendation that we dismiss this one.
Yes, ma'am.
Commissioner Smith makes a motion to dismiss case number 61. Is there a second?
Second.
Seconded by Commissioner Moffitt. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously.
I also want to be clear for the benefit of the program staff that we did not receive that information until after the consent order was already sent. So I don't want them to think that we're making light of it either. It was just a horrible situation and notice wasn't given, and that's how it ended up on the legal report. So I just wanted to make that clear.
Thank you.
Yes, sir.
Case number 89, and I think linked with 90.
Yes, those are
Okay.
mine.
Ms. Carter?
So yes, I wanted to discuss these cases together. There's a lot going on, so I'll try to keep it as brief as possible. So in 89, the respondent is a real estate firm, but this all relates to the same like incident, interaction, and involve the same kind of people. So in 89 and 90, an affiliate and principal broker, they co-listed multiple parcels of land for sale. And then when a neighbor noticed that the parcels were for sale, they contacted the firm, the principal broker, the affiliate. A lot of people let them know there were sinkholes on one of the parcels of land. And actually was very, very adamant about it, would even kind of show up to the property and let prospective buyers know as they were watching the property. There was like no disclosure, anything that was publicly available to agents or any potential buyers. And the principal broker stated that the affiliate was the main person who was the contact agent, and they didn't really know much about it, other than just kind of talking to the buyer and asking them specifically if they knew anything to disclose. The owner said that they didn't have anything to disclose, so they didn't actually put anything on there. So they didn't have actual knowledge of what they were arguing. The buyer stated that after purchasing the property, they became aware of it. That's when the neighbor kind of met with them for the first time and was unaware that there was a sinkhole on the parcel, or one of the parcels. There were three. They were unaware of it. The only thing they were aware of is that they had failed a percolation test at one point, but they were okay with that just for like the use of it, but they were unaware of the issues.
With the sinkhole.
And so I have multiple situations that I
Yeah.
wanted to recommend. The first one was, since this is just against the firm, to close this one and administratively open one against the affiliate who was involved in the situation.
All right,
And
so
then
stop-
the principal
stop
broker is
there.
the. I'm
Stop
sorry.
there. So you want to close your case against the firm,
Against the firm, because I believe it's the principal broker who has
Okay.
most of the
and
responsibility.
then administrative will open one against the affiliate.
Yes,
Okay.
and then
Hold on,
the,
hold on.
oh, so sorry.
I want to, because there is a lot there, so I just want to, maybe we could break it up so that we know what's going on. So, is there we'll go ahead and do a motion to accept council's recommendation to close, which case number?
It would be 89, the one ending in 4321 against the firm.
All right, so it'd be to close or dismiss?
Close this one and open administratively against the affiliate.
Okay. To close this case against the firm and administratively open a case against the affiliate.
And the affiliate is not 90?
The principal broker is in 90, that's the respondent.
Ah,
I make a motion that we close the complaint against the firm and open a complaint against the affiliate on number 89.
Second.
Commissioner Smith makes a motion to close the case number 89, and administratively open a case against the principal broker, seconded by Commissioner Moffett. Any further discussion on that motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Okay, case number
And
90.
then 90 is against, the respondent is the principal broker in this one.
Okay,
And same facts.
same facts.
Complaint in this one, I think, is the neighbor, whereas in number 89, it was the buyer. But if you guys do determine that there is a violation, I have a couple recommendations. For failing to properly supervise the affiliate, failure to exercise reasonable skill and care, failure to disclose to each party any adverse information, failure to verbally disclose any adverse facts known,
So,
and then the agency documentation, there was an unrepresented buyer.
so do we have anything in the record that says there is actually a sinkhole on the property?
They went, like the buyer said that they went after they had purchased the property and they went to, I forgot which office, but they essentially confirmed that there were issues and there were sinkholes there.
There was.
There were issues and they were,
But they
because
did-
they couldn't use the property.
But we don't have a record of that, is that correct?
They did not provide it, no. I just have the plots of land,
And you
the
said
parcels.
this was after closing?
This is after closing. That's what they learned. But I think the concern was mainly because the firm, respondent, and different agents within that firm were aware that
So the-
someone was complaining, the neighbor was, they made multiple attempts to disclose it, so that all
So
parties
the
were
complainant
aware.
the complainant is alleging that the principal broker should have known?
Yes.
So that's imputation of knowledge, though.
It was the adverse facts, like they had something that they should have known about. They didn't disclose it to the buyer at all. So if they had,
Right. But so what you're saying is the prior knowledge, the neighbor telling them that,
so the neighbor, like letting them know and kind of saying like that they had sinkholes on their property, so that's how they knew that there was issues. They also were aware of the issues, and kind of brought to their attention. And so, since it was an unrepresented buyer, essentially just like a duty to kind of like look into it to see if there's anything to it other than just relying on the owner saying that there's no issue.
Owner said
An
there
order
was no
system.
issue. Filled out a disclosure saying there was no issue.
Correct.
But neighbors say there's an issue
The neighbor said there's an issue
on their
because they,
property.
on
because they
their
had,
property,
they had
but didn't
sinkholes.
say, and just saying, be aware of what's on your property.
Right. And then
So,
they had.
so the neighbor has no direct knowledge of what may or may not be on this
That was the-
property in question.
That was the argument made, and then there was also a discussion of them looking into it, the principal broker and the affiliate looking into it. And the affiliate said that they had told the buyer about this potential issue,
Who told the
but
buyer?
that's what the affiliate said.
The
So they-
affiliate said, I told the buyer that there
Right.
could be sinkholes.
Right, and then the buyer said that that was never disclosed.
Okay. And no records of that conversation.
No.
Imagine that.
No emails, no memorialization at all?
No, nothing signed saying that they were aware that they had that conversation and
But
they went forward with it.
Yeah.
So, but they're in
But
conflict.
the buyer's contract was no contingencies, no inspections.
They had tests because they were, it was parts of the
preparation.
land.
Yeah.
They had a test for
Work test, septic.
yes, for the septic tank, yeah, sorry, thank you.
Well, it says here that the complainant bought the property at full price with no inspections.
That's, they were aware that there was a test that was already done and that had already failed, so like that part.
For the septic, but not for sinkholes.
Correct.
Has the complainant filed any other lawsuits or actions against the seller?
Not that I'm aware of.
So the complainant closed on what property they're now saying has sinkholes that they didn't know about because they weren't, it wasn't disclosed to them by the broker.
Yes.
Do we know the size of the property?
1 minute. I got
Yeah.
some,
The complainant
Maximum.
alleges the property's unusable, so I don't know, yeah.
I don't know either. Because the affiliate says they went out and took pictures to send to the complainant, and they didn't see any sinkholes.
Yeah, I mean, the organics can hang over a sinkhole for quite a while, even though there's nothing underneath it. So unless there's a giant open chasm, it's kind of
So
hard to,
that's like-
it's kind of hard to see a sinkhole until it opens.
Okay, and then it says, the buyer was excited to close on the property, and the plans they had would not be affected by the percolation test or other claims regarding sinkhole. That's what the respondent said.
and to answer your question, this particular tract of land was 4.92 acres.
Nothing
Okay,
is
so
5 acres.
pretty big,
4.9.
it's pretty big.
Do you have the price?
Let's see, I think they may have just sold it all like 3 together. Let's see.
Now, I'm kind of interested, I mean, the principal broker co-listed, so I wonder if it was, okay, I'll co-list with you, but I'm not working it, you're working it.
I think that's essentially
And
how
they had
how it happened.
some kind of arm's distance from it, like, I mean, isn't that usually how that works? No? And in terms of the affiliate, I know they didn't memorialize it, but we only have a he said kind of thing.
Right.
The other thing, the neighbors coming over telling people there's sinkholes on the property. The seller says there's not any sinkholes on the property. So,
I think the
as an
neighbor wanted to
agent,
buy the
who do I
property.
believe? And I go out there and I don't see any sinkholes, what am I supposed to do?
Yeah. I wanted you to price that. Says, hey, I need that land.
The price is around $20,000, I believe, what the listing has it as for the 4.9.
What was that?
$20,000 for the 5 acres, and there was 2 other.
20,000 for 5 acres? Whoa.
Hey, Commissioner Gwynn, what's your opinion of that
I
deal?
mean, you get what you pay for.
You deserve it.
As long as it's not a toxic waste dump, I mean, that's about,
Commissioners, do we think the principal broker did anything wrong in this deal at all? I mean,
Realistically, how many times do you list property, 5 to 10 acres, and we walk the entire property? If we're being real,
yeah.
same
Being
goes for,
real.
Well,
same goes for the buyer, though.
well, I mean,
same goes for the buyer, but I'm
this
just
commission does
saying.
have recent experience with somebody who did walk the
Yes.
entire property.
So, and then we also, I'm just thinking out loud, and we rely on the seller. Seller, you got any problems with this property? You got any sinkholes? You got any dead bodies? You got a cemetery? What's going on?
Right, right. Thank you for saying cemetery.
We've been down that road too. I'm just saying, at some point, we have to rely on what the seller says.
That's right.
I'm just thinking out
Yeah.
loud. Yet, at the same time, as a buyer, if I'm going to buy 4+ acres, and I'm excited about it, I'm probably going to get on a vehicle of some sort and ride it or walk it,
And hopefully not fall into a sinkhole.
and hopefully not fall into a sinkhole. I'm just working my mind here out loud, so I'm a little slow, so go with me. So I'm not, you can fuss at anybody about anything,
This is true. Well, it's your pleasure, commissioners. I mean, we can put
I
in
make-
citations, or we can do
I
something.
make a motion, we dismiss.
Second.
All right, I got a motion to dismiss case number 90.
Yes.
With
Bye.
that, sorry, with that said, since it's connected to number 89, would that also apply to the affiliate? Would you like to go back and dismiss that one if there's no violation found?
Let's vote on this, and then we'll go back to 89 and see if we want to rescind that. Is
Okay.
that right?
Yeah, we'll have to do a motion to reconsider, but we
Yeah.
can bring it back up.
Yeah.
All right, so we're back to case 90. We're going to make a motion to dismiss this case, number 90, against principal broker, made by Commissioner Gahn, seconded by Commissioner
Moffett.
Commissioner Nguyen. Any further discussion on case number 90? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Is there a motion to reconsider case number 89?
Make a motion, we reconsider case number 89. Mike, you want to make a motion on that?
Is there a second?
Mike, you want to reconsider 89?
Yes.
You're going to second? I have a motion by Commissioner Smith to reconsider case number 89, seconded by Commissioner Gahn. Any discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion passes unanimously. Case number 89 is on the floor. What's your pleasure, Commissioners?
Make a motion, we dismiss number 89.
Is there a second? Got a motion by Commissioner Smith to dismiss case number 89, seconded by Commissioner Moffett. Any further?
Yeah, we dismissed 89 and we opened a administrative
Against the
against the affiliate. So really wanted to
Okay.
talk about the,
Dismiss the case against the affiliate and not open that complaint now?
That's what I thought we were talking about.
Yeah, we are talking about that. You're right.
So it would just be that the complaint is dismissed.
So, yeah.
Did I do it right?
You did it right.
It would just be that the complaint is dismissed.
Right.
Because that would be the recommendation.
against the affiliate.
Yes.
Well, period.
We would
Period.
just,
Okay.
yeah.
Okay.
So, okay, good. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Thank you, Commissioners. Thank you, staff and council. Any new business before the commission?
I have two things. For those attending in person today, thank you so much. We hope you have learned something that will help you in your real estate career and what not to do. We also want to thank the Central West Tennessee Association of Realtors for providing a facility for training yesterday. We hope those that took part in the training yesterday learned something to help them grow in their profession. We also want to thank them for assisting us with the meeting today. We also want to thank Alvin with the City of Jackson for helping us set up today and yesterday. And thank you to the City of Jackson for hosting us so we can conduct the TREC meeting. That concludes my remarks.
Okay. just to
Oh,
notify-
yes, and please, those that are here in person, please sign out in order to receive credit.
Also, to remind everybody, our next meeting will be December 17th in Nashville. Hope y'all can attend.
And there will be a rulemaking hearing.
In addition to the rulemaking hearing.
It's your favorite.
In addition to the rulemaking hearing, there will be a luncheon with TREC employees and the commission as well.
We like those.
Yes, thank you.
Anything else? Hearing none, we are adjourned until December. Thank you.